Hi, this week's video lecture is on Chapter 6, which is Defenses of Criminal Liability. So here we're still kind of working with this framework where the defendant pleads not guilty, then admits to the underlying conduct, but says that the conduct is excused for some reason. Our excused defenses are made up of the insanity defense, defense of diminished capacity, the excuse of age, the defense of duress, the defense of intoxication, the defense of entrapment, and syndrome defenses. Okay, so starting off with the insanity defense, this is kind of the most well-known of these defenses, I think. Insanity has a long history. It goes all the way back to Plato, where he discussed in his writings that we should not convict those who are not culpable for their actions. Insanity is part of our common law from the Regina v. McNaughton case. In McNaughton, he thought he was going to assassinate somebody, and he had the wrong person, and as part of the trial, it came out that he was insane. He was delusional, he had a serious mental illness, and that his insanity caused him to attempt this assassination, and so he was found not guilty. And so that's kind of where insanity gets started from. There's a lot of kind of myths about insanity. A lot of times people think that insanity defense is really common. It's hardly ever used, and it is used less than 1% of the time in 0.87% of criminal cases across the country. And of that 0.187, 23.5% are actually successful in establishing that they are insane. People often think that insanity is only for use in homicide cases, and that's also not true. It is just a general defense that can be raised. When people also think that when you plead insanity that you might just walk, and that is also not true. If you are successful in pleading your insanity defense, if you are in that less than 1%, that 23% of the less than 1% who are successful, you will be civilly committed to an institution. Okay, so proving insanity. There's two different things we need to talk about as far as stages in the process. One is when the crime was committed, were you sane or not? If you were insane, then we will excuse your actions. If you were sane, your actions cannot be excused. And we presume that all criminal defendants are sane. We have this presumption that you're sane. You have to rebut that presumption with evidence, to a preponderance of the evidence to demonstrate that you were insane. When the defendant is charged and tried, they need to be competent. So defendants may successfully get a competency hearing, which will attempt to determine can this defendant participate in their own defense, because you do need to be competent to stand trial. So we have 4 different insanity tests. The first one, the most common one, is the McNaughton rule from that McNaughton case in the first slide. This is the oldest rule. It's used in 28 states and the federal courts. Here, the defendant needs to have suffered a defect of reason caused by a disease of mind. And because of that, they did not know the nature and quality of the act, or that the act was wrong. A mental disease here, a disease of the mind here, really only means psychosis. You need to be psychotic to successfully plead insanity. The most common diagnosis that comes along with this is paranoia or schizophrenia. So this is not just, it could include other ones, but the most common ones are paranoia or schizophrenia. The defendant needs to be in a state of psychosis to successfully establish insanity. Before we move on, so this is it's called McNaughton, the right-wrong test, and I wanted to pull up and show you Indiana's insanity defense. Here we have Title 35, Chapter 41, 3.6, where we can see in Indiana's insanity defense says a person not responsible for engaged in the prohibited conduct if as a result of a mental disease or defect he was unable to appreciate the wrongfulness of the conduct at the time of the offense. As used in the section, mental disease or defect means a severely abnormal mental condition that grossly and demonstrably impairs a person's perception. But this does not include those things that are manifested only by repeated unlawful or antisocial conduct. So this is getting at that you are in a state of psychosis at the time that you act. Okay, so that is the most common rule for insanity. That this is the rule that Indiana is using. There are a couple of other tests that we're going to run through and talk about. They may be on the exam. The irresistible impulse test is the next most common. Only a few jurisdictions use this. Under the irresistible impulse test, we don't hold people with a mental disease or defect responsible when they know what they're doing is wrong, but they cannot bring their actions into line. So they have a mental disease, a mental disorder that impacts their ability to conform their behavior to the law. So they can tell you that what they did was wrong, but because of delusions, because of this illness, they cannot actually engage in appropriate behavior. If so, in these few states, defendants can successfully plead insanity. Product of the mental illness is only used in New Hampshire. This is also called the Durham Rule. And here, acts that are products of the mental disease or defect excuse criminal liability. So this is the broadest of the rules. The next test is called the substantial capacity test. This is the model penal code test. It kind of brings in a couple different elements. This is the rule in 14 jurisdictions. And here, a person is not responsible for criminal conduct if at the time of such conduct, as a result of the mental disease or defect, he lacks substantial capacity either to appreciate the criminality, wrongfulness of his conduct, or to conform their conduct to the requirements of law. So this is combining the irresistible impulse test and the McNaughton test into one test to try and really capture people who are insane. So these are kind of the model penal code. Defendants can have some capacity, but they need to be able to not conform their behavior to the law. So there's a test in your book about Myers. I'm going to give a different example that's not in your book. In my example, the Myers case is actually from Indiana in 2015. He was found guilty but mentally ill after a jury trial. He was diagnosed with paranoid schizophrenia. He'd been in and out of hospitals for his mental health. At this time in question, he was kind of stopped taking his antipsychotic medications. There's a lot going on in this case, so I definitely encourage you to read it. This is from Indiana. They're applying our state's insanity test. He some of his behaviors here, okay, we'll just take a break. The day in question, some people are driving in a car, they heard a loud sound, they turn around to see someone running at their vehicle, pointing a long gun in their direction. Then another gunshot was fired towards them. They drove the vehicle out of the town onto the interstate and saw the man who fired the weapon running along the road. They called 911. The person who was shooting was identified as Myers. Shortly after that, somebody else was driving along US 20 when they saw Myers walking down the road heading eastbound. They saw a vehicle coming the opposite lane. They turned around to check on him. They saw that he was holding a gun. They quickly turned around. When they were doing this, Myers shot twice at their vehicle. He was driving with the windows down. He heard the bullets flying by. He called 911 and requested the police to come. Several police officers were dispatched, and they found him standing in a ditch near the road. When they approached him, he fired a gun direct. An officer approached him in the cruiser. Once the cruiser was parallel with his location, he fired shots in towards the driver's window. At this point, the trooper turns the vehicle around, gets out, and orders him to stop. Myers ignores this and starts walking away. The officers follow him, continuing to order him to stop. Different officers approaching from the opposite direction after hearing the dispatch that shots were fired at a police officer. He pulled his vehicle across the other side of the highway to block traffic. At this point, they continued to yell at him to stop, but he just appeared to look through him and then he continued to walk, so he's not responding to police officers. A trooper fired at him and hit him near the shoulder. Myers then reacted and turned away. Eventually, Myers retreats into a woodside area along the road. Officers establish a perimeter to keep him from exiting. As more law enforcement officers arrive, they attempted to negotiate, and gas was eventually fired into his location to force him out. Even despite this, he remained in a bush. Finally, police had to resort to the use of an armored vehicle and a tactical team to apprehend him. Myers was immediately taken to the hospital because he had suffered 2 gunshot wounds. Myers had this long history of mental health. Myers asserted this insanity defense. So the question is, and he has paranoid schizophrenia, which clearly satisfies. And the question is, does he understand the difference from right from wrong? The trial court does note that based on sometimes that some of his behaviors have been recognized by demonstrating consciousness of wrongdoing, such as walking away from the officers. So this is kind of a great contemporary example of the use of an insanity defense. I'm going to stop the video here and upload a new one with all the other information outside of insanity. So insanity gets pretty complex. I really encourage you to work through all of these definitions in this particular case to really examine the facts in detail. These tests will all be on the exam, okay?